stated that the ballot box for the polling station, for the said polling station, was opened at the said center and votes counted in the presence of all agents and the results announced at the tallying center at Garsen High School. This witness, however, kept on contradicting himself. When cross-examined by Mr. Wenner, he admitted that the affirmative affidavit that he went to the tallying center and found that there were issues being raised about Kitere Primary School polling station, and the complaint that was that the form had not been signed by the agents. And the complaint then was that the form had not been signed by the agents. He admitted that in his affidavit, he had deposed that the ballot box was opened and the votes counted in the presence of all agents. On being cross-examined by Mr. Mutugi, Gawawa Said Bashora stated that he was not there when the ballot box was opened. On being re-examined, he stated that he was at the tallying center when the ballot box for Kitere Primary School was opened and the votes counted, and that the agents were called to sign for that 7A, and they did so, and there were no complaints. This court notes that the above witness kept on flip-flopping in his evidence as to whether he was at Garsen Constituency Tallying Center when the ballot box for Kitere Primary School was opened or not. In the same circumstances, his evidence is not credible and it cannot be relied on to render credence on the allegation that the gubernatorial ballot box for Kitere Primary School polling station was opened for purposes of counting of votes. On his part, the Garsen County Returning Officer, the third respondent, went to the Garsen Constituency Tallying Center on the request of the Constituency Returning Officer, who informed him of a standoff between her and the agents about the opening of a ballot box, and as the presiding officer had locked the polling station, the ballot box. His evidence was that he confessed that the law allows for the opening of boxes. The second and third respondent witness, number 2, Hadija Mohammed, who was the constituency returning officer for Garsen, authorized the presiding petition to open the ballot box to retrieve the polling station diary and not for purposes of recounting of votes. That's what she said. In his submissions, Mr. Miller stated that the presiding officer, I had already said this about what Mr. Miller said, that Mr. Miller said that the presiding officer of the same polling station had in his affidavit deposed that he had locked the polling station diary in the gubernatorial ballot box. I'll repeat that. In his submissions, Mr. Miller said that the presiding officer of the same polling station had not in his affidavit deposed that he had locked the polling station diary in the gubernatorial ballot box, and that his abatement was that he forgot to sign that Form 37A for Kitere Primary School Polling Station 1. Mr. Miller also brought up inconsistencies in the evidence of the same presiding officer as to who between him and the constituency returning officer opened the ballot box. Brad Wafula Wanjala, the presiding officer for Kitere Primary School Polling Station 1, who testified as the second and third respondent's witness, number 4, was cross-examined by Mr. Wenner, and at first appeared to be non-committal on who opened the ballot box for the same polling station between him and the constituency returning officer. His evidence was that of the ballot box in the presence of all the polling stations, all the party agents and the constituency returning officer. On being cross-examined by Professor Ojienda and re-examined by Officer, Kitere Primary School Polling Station maintained that the opening of the ballot box he opened polling station diary. The constituency returning officer corroborated the evidence of the presiding officer, Kitere Primary School Polling Station, that the purpose of opening the gubernatorial ballot box for Kitere Primary School Polling Station was to retrieve the polling station diary. And so did the county returning officer, who also testified. This court has no reason to doubt the reasons given by the witnesses as to why the ballot box was opened. That is the four witnesses. As to why the ballot box for Kitere Primary School polling station number 1 was opened. I watched Fred Wafula Wanjala testify. He came across as a witness of truth. He owned to not having signed Form 37A for Kitere Primary School polling station due to fatigue. He did not try to cover up his omission by requesting the constituency returning officer to allow him to sign the same at the polling center. This court has considered the Kenya Gazette notice number 9978, volume CX1X, number 1, which is 12th October 2017, which provides for the procedure to be followed for retrieval of electoral materials that have been wrongly put in ballot boxes. I therefore hold that the opening of the ballot box for Kitere Primary School polling station was done in accordance with the law. And in the course of the proceedings, the petitioner brought up the issue of the answer 37A for Kitere Primary School polling station. This court, after perusal of the petition, notes that the said issue was not pleaded at all in the petition. At the time of filing of the same petition, the petitioner had in his possession Form 37A for Kitere Primary School polling station 1, but did not plead on the issue with specificity, despite the fact that he had the said form. On unpleaded issue, this court is guided by the Court of Appeal decision in IBC, in IBC, and another versus Colin Akai Lo Kuruka and another, where the court recently restated by this court in IBC and another by Stephen Mutinda Mule and 3 others, that parties are bound by their pleadings which each a trial court may pronounce. And the Supreme Court has explained the rationale in Zakaria Okoth Obado versus Edward Akongo Oyugi and 2 others. The Court of Appeal also said that it is vital in election petitions that the respondent should know the case that faces him or her. Hence, the petitioner ought to have indicated in his or her pleadings the disputed matters with clarity and specificity as a basis for being allowed to urge that there were irregularities in those spheres. It is true that the petition, that is the Court of Appeal, it is true that the petition raises complaints of irregularities in lacking security features, signatures of agents, and IBC stamp. Who were not authorized arms, which were not consigned, and forms without number of registered voters. Raila Amolo Odinga and another versus IBC and 2 others. Supreme Court decision of 27, where the Supreme Court quoted with the Supreme Court of Benin decision in in absence of pleadings, evidence, if any, produced by the parties cannot be considered. It is also set on legal proposition that no party should be permitted to travel beyond its pleadings, and parties are bound to take all necessary and material facts in support of the case set up by their pleadings. Ensure that each side is fully alive to the questions that are likely to be raised, and they may have an opportunity of placing the relevant evidence before the court for its consideration. The issues arise only when a material proposition of fact or law is affirmed by one party and denied by the other party. Therefore, it is neither desirable nor permissible for a court to frame an issue not arising in the pleadings. Also, in the case of Nadif, Jama, Adam, Abdi Kaim, Osman Muhammad, and 3 others, the Supreme Court stated the importance of this requirement as follows. From the foregoing passage and from the record, we find that the authenticity of the results on the unsigned and unstamped forms that 35 had not been the subject of challenge, but there had been an irregularity in the handling of statutory forms from the polling station. There was no explanation of how that irregularity affected the results of the election. This clearly is a censorable condition, but in a dutiful resolution of a legal and electoral dispute, the fundamental question is the constitutional franchise right of the people inhabiting the electoral area. It is this to be protected in circumstances such as those unfolding in this instance. The default view of being that of election presiding officers failing to have forms duly signed and stamped. Those respondents have an obligation in the circumstances to show that the irregularities were of such a gravity as to vitiate the results, and the winner is no longer in real terms the winner. Therefore, as submitted by the counsel of this for the second and third respondents, the issue of the non-signing of Form 37A for Kitere Primary School was not pleaded. And as I started addressing Kitere Primary School, I reproduced what was pleaded about that primary school. And had the petitioner pleaded on the issue of the unsigned Form 37A for Kitere Primary School Polling Station 1, it would have enabled the first respondent and the second respondents to respond to the same. This court will therefore not delve into determining the issues, the unpleaded issue. On the allegation that it is not an allegation, on the issue that the constituency Form 37B was signed by the county returning officer instead of the constituency returning officer, the petitioner has not proved on a beyond reasonable doubt, on an intermediate stage, that the irregularity should vitiate the results of the election petition. On whether Form 37B for Bura constituency contained results for Ali Wario, Kea Batuyu, and Suleiman Buyu Yese. PW1 alleged that Ali Wario, Kea Batuyu, and Suleiman Yese were missing from that Form 37B for Bura constituency. Were missing from Form 37B for Bura constituency. He referred the court to page 169 of the petition, which contains the said Form 37B. On being referred to the said form, he contended that the results in issue were not reflected. He further referred to page 393 of the second and third respondent's response and stated that the names of Ali Wario, Kea Batuyu, and Suleiman Buyu Yese are reflected thereon, but in the total tally at page 394, their votes were not tabulated. This court notes that an explanation in regard to the said allegation. Mr. Munyedia submitted that during cross-examination, the petitioner was referred to page 393 of the IBC documents in response to the petition, and he admitted that indeed Form 37B contained the results for Ali Wario, Kea Salim Batuyu, and Suleiman Batuyu Yese. He was further referred to page 395 of the IBC document, and he admitted that indeed Form 37B was signed by the constituency returning officer by the name Jamanda. The determination on that issue is that this court has looked at the documents which form the basis of the allegation in issue, and more specifically the Form 37B for Bura constituency, which shows that the results for each gubernatorial candidate, including Ali Wario, Kea Batuyu, and Suleiman Buyu Yese from all the polling stations, were captured on the said form. The total number of votes garnered by each candidate in Bura constituency was also captured. The omission that was made by the Bura constituency returning officer was failure to include the names of Ali Wario, Kea Batuyu, and Suleiman Buyu Yese in the schedule showing the aggregate scores for each candidate. It must, however, be noted that the figures in the same schedule are derived from the total number of votes garnered by each candidate, which is captured on page 394 of the second and third respondents' bundle of documents. It is apparent that the names of Moroa Hassan Bali and Kaduda Michael Justin have been captured twice in the said schedule of the aggregate scores. And that's how the names for Ali Wario, Kea Batuyu, and Suleiman Buyu Yese were omitted. The above notwithstanding, the petitioner failed to demonstrate to this court how the above error in transposition of votes affected the outcome of the results, and in particular, the total number of votes he garnered at Gura constituency. Form 37B shows that he garnered 5,846 votes, and the same number of votes are captured on his aggregate results. The above allegation is therefore unmeritorious, as it does not affect the validity and the legality of the results. The other issue is on failure to provide sufficient ballot papers for governor elections at Nangwadi Primary School Polling Station and Kabawells Station, leading to voter suppression. It was the petitioner's case that at Nangwani polling station, which is in Galole constituency, the second respondent availed only 113 county governor's ballot papers for the election, yet there were 226 registered voters. PW1 referred to page 238 of the petition, which contains Form 37A for Nyangwani Primary School Polling Station, and stated that the presiding officer for the state station commented at the bottom of the said form that there was a shortage of county governors by a half of the total registered voters, but through consultation with agents and voters, they unanimously agreed to vote without the missing half. That was an error in English by the presiding officer. He averred that he was informed by his agent, Ahmed Hero, that 46 voters were turned away for lack of county governors' ballot papers. PW1's view that if said 46 voters had been given an opportunity to vote, the election results for that particular polling station and Tana River County at large would have been different. As for Kabawells polling station, the petitioner stated that it has 135 registered voters. However, only 69 county governors' ballot papers were provided the second respondent, resulting in 66 registered voters being denied an opportunity to vote. He also stated that his agent by the name of Kariu informed him that the said 66 voters were tied. He asserted that the shortage of ballot papers led to disenfranchisement of voters, thus affecting the final results. PW1, however, also agreed in close examination that the shortage of ballot papers affected all the candidates vying for the governor's electoral seat. The petitioner explained at Kabawells polling station is on the shortage of ballot papers, which has a bearing on the right to vote. Maro Awad Mohammed testified as PW5. He is a registered voter and was UDA's agent at Nyangwani polling station. His evidence was that there was a shortage of ballot papers for the election of the governor. His evidence was that there was a shortage of ballot papers for the election of the governor at Nyangwani polling station. He contended that Form 37A contained at page 238 of the petition was signed by Ahmed Hero of UDA. However, he does not know everyone who goes by that name. He does not know anyone. PW5 asserted that when the IBC officials realized that there was a shortage of ballot papers for the county governor, he counted the people remaining in the queue to vote and found that 46 people are still waiting in the queue to vote. He stated that this was one of the petitioner's strongholds. The presiding officer for Kabawells mobile polling station was Peter Karanja Minor, who testified as PW6. His evidence was that only 69 people voted for all the electoral positions because there were only 69 ballot papers for all of them. He, however, contradicted his testimony and stated that after 69 voters had voted, they realized there was a shortage for the county governor's ballot papers, and other elective posts had sufficient ballot papers. The first respondent averred that Nyangwani polling station was his stronghold. However, there was a shortage of county governor's ballot papers at the said polling station and Camberwell's polling station. He stated that since there was only one day for voting, the shortage of ballot papers could not be addressed on the day for elections. The first respondent asserted that despite the shortage, the elections were credible and verifiable. It was the third respondent's evidence that indeed there was a shortage of the county governor's ballot papers at Nyangwani and Camberwell's polling stations, which was discovered after voting had started. Which was discovered after the voting had started and was ongoing. But the said shortage was not deliberate. He testified that he does not know the number of people who did not vote. In addition, from the information he was giving, voting for all the other 6 electoral seats continued at Camberwell's polling station. It was stated by the third respondent that the second respondent was in charge of procurement of ballot papers and other election materials. The constituency returning officer for Galaule constituency, Siat Mahat Sabul, testified as witness number 5 for the second and third respondents. He stated that the presiding officer for Nyangwani Primary School polling station informed him of the shortage of ballot papers at 2 p.m. On the day of elections. He further stated that the total number of registered voters was 226 and the valid votes cast were 113. Abdul Swaleh Jamenda, the returning officer for Bura constituency, on the other hand, averred that he was informed by the presiding officer for Camberwell's mobile polling station of the shortage of ballot papers at around 4 p.m. However, no voting went on between 12:47 p.m. and 7 p.m. when the polling station was closed. Another witness by the name of Hasina Ravule Abdallah testified as witness number 6. She stated that she was the presiding officer for Nyangwani polling station, which had 226 registered voters. However, only 113 voters cast their votes for the position of the governor. She confirmed that she commented at the bottom of Form 37A that there was a shortage of county governor ballot papers by half of the registered voters. However, through consultation with the agents and voters, they unanimously agreed to continue with the voting without the missing half. She stated that 159 voters cast their votes for the other positions. Save for the governor, where only 113 people voted. Mr. Miller submitted that it is not disputed that there was indeed a shortage of ballot papers for the governor election by half of the registered voters at Camberwell's mobile polling station and Nyangwani polling station. In Nyangwani polling station, he stated that in Nyangwani polling station, all the 113 ballot papers that were supplied by the second respondent were used, and as a result, 46 voters who turned up were not able to vote. He contended that when it comes to Camberwell's mobile polling stations, there were 135 registered voters. However, the second respondent only provided 69 ballot papers for the election of governor. Consequently, 66 voters were denied their right to vote for a governor of their choice. He also submitted that failure by the second respondent to provide sufficient ballot papers for the election of governor was a violation of Article 38, Sub-Article 3B of the Constitution of Kenya, which gives every adult citizen the right without unreasonable restriction to vote by secret ballot in any election or referendum. And Article 81E of the Constitution of Kenya, which requires an election to be conducted in an efficient manner, thus sufficient to justify the election, regardless of whether or not the violation affected the outcome of the election in terms of votes garnered by respective candidates. Mr. Miller asserted that the right to vote is symbolic to citizenship and has constitutional importance. Therefore, this court should deal with any case concerning an infringement of the right to vote very seriously, being mindful of the deep democratic value that lies in citizenry, conscious of its civic responsibilities and willing to take the trouble of exercising that right. He stated that a total of 115 voters at Kabawel's Mobile and Nyangwani Primary School polling stations were disenfranchised. Therefore, when this number is considered alongside other irregularities, the breaches, while bearing in mind that the margin of victory was 259 votes, this court can only conclude that the election did not meet the threshold of being accurate, efficient, and verifiable, since it is impossible to ascertain who won the impugned elections. Professor Ojenda, senior counsel for the first respondent, submitted that in Nyangwani Primary School polling station, none of the alleged 46 voters who did not vote due to shortage of ballot papers saw any affidavits to this effect or to the effect that they wanted to vote for the petitioner, but were turned away. This notwithstanding, but he, however, said that notwithstanding, that was the first respondent's stronghold and not the petitioner's. Counsel further submitted that no one could tell who the alleged 46 voters could have voted for, since the shortage affected all the 13 gubernatorial candidates. He referred to the case of Henry Okello Nadimo versus IEBC and two others, where the court held that no single candidate was disadvantaged by all the errors. The anomalies did not seem to be designed to benefit or prejudice any candidate, and to benefit any candidate. That was submission by Mr. Miller. And one cannot seek to have an election overturned based on the allegation alone. On his part, Mr. Munyidia, learned counsel for the second and third respondents, submitted that the petitioner failed to demonstrate through evidence the specific number of voters who did not vote because of the shortage of ballot papers. He further submitted that he did not annex the results of the other elective positions, neither did the said 46 voters deponed witness statements. He contended that PW5 Maro Awad Mohammed is not a credible witness, since although he claims to be an agent at the polling station, someone else signed Form 37A in place of the petitioner's agent. Mr. Munyidia asserted that the shortage of ballot papers was adequately explained by the first respondents and their witnesses. In addition, when the shortage was discovered on the material day, there is basically nothing that could have been done. He further asserted that the shortage of ballot papers was not deliberate, was occasioned by the printing machine, which is operated outside the country. Mr. Munyidia contended that no evidence has been adduced to show that there were voters who were waiting in line to vote, but they could not due to shortage of ballot papers. And even if there were, there is no proof that they would have voted for the petitioner. He submitted that the shortage of gubernatorial ballot papers affected all the candidates. Therefore, the allegation propounded by the petitioner on voter disenfranchisement does not hold water. And he relied on the Supreme Court decision in Raila 2022 on the shortage of ballot papers. This is the court's determination on that issue of shortage of ballot papers. It is not disputed that there was a shortage of ballot papers for the county governor at Nyangwani and Kabawel's polling stations. PW1 stated that Nyangwani polling station was his stronghold, and he was informed by his agent, Ahmed Hiro, that 46 voters were turned away for lack of county governor's ballot papers. This evidence was corroborated by Maro Awadhi Mohammed, who testified as PW5 and as he was a registered voter and UDA's agent at Nyangwani polling station. The petitioner asserted that if the said 46 voters had been given an opportunity to vote, the election results for that particular polling station would have been different. Upon perusal of Form 37A for Nyangwani polling station, it is evident that it was signed by Ahmed Hero of UDA. He also said in cross-examination by counsel for the first respondent, PW5 stated that he did not know who the said Ahmed Hero was, and therefore this court has no way of establishing whether PW5 was at Nyangwani polling station on the day of the elections, and whether his testimony is true, a true representation of what transpired at the said polling station. The petitioner contended that the shortage of ballot papers led to disenfranchisement of voters, thus affecting the final results. He also agreed that the shortage of ballot papers affected all the candidates vying for the governor's electoral seat. It was stated by the first respondent that Nyangwani polling station was his stronghold, and he further stated that despite the said shortage, the elections at the polling stations were credible and verifiable. The third respondent, on the other hand, averred that he stated that inasmuch as there was a shortage of the county governor's ballot papers at Nyangwani and Kabawel's polling station, which was discovered when voting was ongoing, the said shortage was not deliberate. And the counsel for the petitioner cited Article 81E of the Constitution of Kenya and said that the shortage of ballot papers led to voter disenfranchisements, since some of the registered voters were denied a chance to vote for their preferred governor. Therefore, this issue is sufficient to nullify the election, regardless of whether or not the violation affected the outcome of the election in terms of the votes garnered by the respective candidates. I had already said that, so let me go further. It is not disputed that printing of ballot papers for the all electoral posts is done outside the country. The constituency returning officer for Galole constituency, Mr. Siad Mahat, testified as the second and third respondent witness number 5 on examination by the court. On examination by the court, he stated that ballot papers are packed in cartons, and the serial number ranges are printed on top of the carton box. The serial number range for Nyangwani Primary School polling station ranged up to 26 ballot papers. However, as voting was ongoing, it was discovered that the printer had skipped some serial numbers, occasioning this shortage. And prior to opening of the carton containing the county governor ballot papers, it was impossible to tell whether or not the ballot papers provided were equivalent to the number of registered voters at the said polling stations. Notably, there is no evidence adduced before this court as to the exact number of voters who were unable to vote at Nyangwani and Kabawel's polling station as a result of the shortage of ballot papers. Upon consideration of the explanation and the evidence adduced before this court by the second and respondent's witnesses, it can easily be concluded that in the event of shortage of ballot papers being discovered, discovered in the course of voting, there was nothing that could be done, since the printing of ballot papers was not done in Kenya. Of the considered view that for this claim to succeed, the petitioner must demonstrate that the second respondent's failure to supply sufficient counties governor's ballot papers was deliberate, was done in bad faith, and was aimed at reducing the petitioner's overall votes, thus affecting the overall results. From the foregoing and as explained herein above, it is evident that the shortage of ballot papers was neither deliberate nor was it in bad faith, as it was discovered when the voting had already started. I find that since this is not an isolated incident, I'll repeat that. I find that since this is not an isolated incident unique to Tana River County, the same can be attributed to a mistake on the part of the second respondent's officials. It is common knowledge that the said officials were tasked with the duty of traveling to Greece. It is common knowledge that the said officials were tasked with the duty of traveling to Greece, as it was in the media, to inspect the templates. To inspect the templates to ascertain that printing of ballot papers was in order. But it seems that they were not diligent enough. The Supreme Court dealt with the matter, that is in the Odinga and 16 others versus Ruto and 10 others, where there was a complaint in that some county governors' positions could not vote together with the other in the other elections. And this is what the Supreme Court said. Regarding this allegation, it has not been shown by postponing elections in the named electoral units, IEBC acted in bad faith or was influenced by irrelevant factors and considerations. From the explanation standard, we are satisfied that the postponement was occasioned by a genuine mistake, which in our view could have been avoided had the members and staff of the IEBC been more diligent when they went to inspect the templates in others. Greece, where the printing of ballot papers was undertaken. Mr. Miller submitted that the elections hearing should have been nullified due to the failure by the second respondent to provide sufficient ballot materials. He also said, because that is a violation of Article 38, Sub-Article 3, Paragraph B of the Constitution of Kenya 2010. Article 83(1) of the Elections Act 2011 provides that a court shall not declare an election paid for non-compliance with any written law relating to the election. That election, if it appears that the election was conducted in accordance with the principles laid down in the Constitution and in written law, and the non-compliance did not substantially affect the result of the election. In this case, the shortage of county governors' ballot papers affected all the 13 gubernatorial candidates, and there is no way of ascertaining which of the candidates they said the voters who did not vote, who are not able to vote, would have voted for in the absence of sworn affidavits or testimony by the same voters. Therefore, the petitioner was not the only one who was disadvantaged by the said shortage. Additionally, looking at the voting pattern at Nyangwani polling station, it is evident that the first respondent had more votes than the petitioner. Thus, in the event all the ballot papers were provided, he would most likely have won in that polling station. At Kabawel's polling station, on the other hand, Al Wario garnered 60 votes, whereas the petitioner got 9 votes. Hence, if the sufficient ballot papers were provided, the voting pattern indicates that Ali Wario was likely to win in the said polling station, that is Kabawel's polling station. And therefore, this court finds that the petition, that ground or that issue fails. A faulty KIMS kits. The petitioner's case is that at Titila and Waiboru polling stations, the KIMS kits failed to identify voters, hence they were unable to vote. Whereas at Godia Primary School polling station stream number 2, the KIMS kit malfunctioned, causing voting to extend into the night without lighting. Hence, many voters at that polling station returned home without voting. It was the evidence of PW1 that at Titila Primary School polling station, 56 voters, among them being Mohammed Agaiso, Golo, Bineso, Adhan, Hussein, and Suleiman, Ware, Gonyo were not identified by the KIMS kit, and the manual register was not used to identify them either. He stated that is PW1, who is the petitioner. He stated that IBC had put measures in place. IBC had put measures in place I'll take that again. He stated that the IBC should have put measures in place to ensure that voters not identified by the KIMS kit could vote using the manual register after filling the requisite form. He referred the court to Form 37A for Titila Primary School polling station, found at page 226 of the petition, and stated that the presiding officer commented that the voting process was smooth. In addition, Form 37A showed that Titila Primary School polling station 1 had 572 registered voters, but only 453 voters voted, which translates to 79% of the voter turnout. PW1 stated that the polling station was in the middle of town, thus so many people turned out to vote. He deposed that he stated that at Wayuboru polling station, 70 voters among the Mohammed Panchor did not vote as the KIMS kit failed to identify them. The petitioner asserted that despite the fact that he won in that polling station with 479 votes, he would have garnered more votes if the other voters not identified by the KIMS kit had been identified by the manual register and allowed to vote. It was his evidence that at Godia Primary School polling station stream 2, the KIMS kit malfunctioned throughout the day, and the voters would go for 30 minutes without a single voter being identified by the said KIMS kit. He stated that as a result, some people were turned away due to the slow voting as a result of the malfunctioning KIMS kit, and elderly people and mothers left without voting after waiting from 6 a.m. till night time. The court was referred to page 343 of the second respondent's documents, which contains Form 37A for Godia Primary School polling station. It's the witness. PW1 was referred, which indicated that the total registered voters therein was 625, and only 4 or 6 voters voted, which translates to over 50%. He stated that he voted at Faraha Primary School, where he was identified on a KIMS kit in the second stream he went to. After the KIMS kit in the first stream failed to identify him, that after he cast his votes, he stayed around for a while, and he noted that many elderly ladies were being rejected by the KIMS kit and had their photographs taken. A form was filled for them, and thereafter they were allowed to vote manually. He stated that that was the correct protocol to be followed when a voter could not be identified by the KIMS kit. PW8 Hassan Kuru Luka testified that he was a registered voter at Titila polling station. However, he and 2 other voters who had queued behind him were not identified by the KIMS kit. He said that in total 56 people were not identified by the KIMS kit, and that there was only one KIMS kit machine, and when it failed to identify them, they stood aside and waited. That they tried 2 more times, but they were still not identified by the KIMS kit. His evidence was that they waited outside the polling station until 9 p.m., but they were still not able to cast their vote. He stated that he was told that if one is not identified by the KIMS kit, his photo can be taken and he can be allowed to vote. However, he was not identified by that mode either, and he was not allowed to vote. He asserted that he wanted to vote for the petitioner. PW9 Yakub Dubedido, the petitioner's agent at Wayuboru polling station, testified that 70 people were not allowed to vote at the said polling station since they could not be identified by the KIMS kit. However, he had no documentation to show that the said people did not vote and that they were registered voters at Wayumboru polling station. He deposed that he stated that he requested the presiding officer to allow 70 people who had not been identified by the KIMS-KIT to vote, but he declines. Hence, he informed the county chief agent, who spoke to the returning officer, and he agreed to allow the 70 people to vote after the presiding officer registered their names on the book. However, the presiding officer declined to allow them to vote manually. PW10, the petitioner's agent at Godia Primary School Polling Station, Stream 2, testified that the KIMS-KIT were not functioning properly, and it was taking about 30 minutes to identify a voter before voters could proceed. He said that each voter was taking about 15 minutes before identified by the KIT. About 52 people would have voted in a time span of 13 hours. He stated that some people who were waiting to vote in the queue were sent away when the National Youth Service personnel went at the back of the queue and stood behind the last person, and the people standing behind him were not allowed to vote. And therefore, as a result, over 100 people did not vote. He, however, did not record their name. He said that between 7 p.m. and 9 p.m. there was no voting, and the ones who were still on the queue left without voting as it was dark, and there were no lights in the room where votes were being cast, and a lamp was only brought at the polling station at 9 p.m. However, during cross-examination by Mr. Mutugi, PW10 stated that he stayed at the polling station until 7 p.m., since the second respondent extended the voting time to 7 p.m. He further stated that he saw the voting material that was at the polling station on the morning of the voting, but he did not see a lamp at the polling station. The first respondent's witness number 9, an agent at Kone Primary School polling station, stated that a few voters were not identified by the KIMS-KIT. A few voters who were not identified by the KIMS-KIT were put aside and had their photographs taken, and they were allowed to vote. The third respondent stated that the identification of voters was to be done using the KIMS-KIT. And if it failed, second respondent's officials to adopt the alphanumeric search mode, where the presiding officer uses the KIMS-KIT and a QR code to search for the name and identity card number of the voters. And if this, they adopt the supervisory mode of identification. He stated that the KIMS-KIT method was used to identify voters at Tana River County, and in addition to at Titila and Wayumboru polling stations, they also used the alphanumeric and supervisory modes to identify voters. He asserted that, to his knowledge, no voter was sent away at Titila and by Wayumboru polling stations. In his evidence, he said that in regard to Godia, School polling station Stream 1, no voter was sent away due to failure of the KIMS-KIT. Since if that was the case, the presiding officer would have recorded it on Form 37A, which he did not. He stated that a security officer is supposed to stand behind the person in the queue, and he was informed that at Godia Primary School polling station, everyone who was at the queue was allowed to vote. He also said that failure of KIMS-KIT is a technological issue. Thus, when the KIMS-KIT at Godia Primary School polling station Stream 1 failed, the constituency returning officer sent the ICT officer to go and start it. And the ICT officer went with another KIMS-KIT. The second and third respondents, witness number 5, stated that at Galole constituency, the mode of identification that was mostly adopted was the KIMS-KIT. However, when this system failed, They adopted the alphanumeric search where the identity card number and name of a voter are input in the KIMS kit. And the supervisory mode, according to her, the supervisory mode was not used in that constituency. He confirmed that he was neither at Itila nor Wayuboru polling stations during the voting process, and he was not told that some people were not identified by the KIMS kit at the said polling stations. Another witness number, who was witness number 7, by the name Idris Colombo Omar, who was the presiding officer at Titina Primary School polling station stream 1. That is a witness for the second and third respondents. Stated that the voters were being identified by the KIMS kit and by the supervisory mode, manually, which entails the presiding officer filling a form to validate a voter to vote, then taking the voter's photo using the KIMS kit while the voter is holding his identity card below his chin. He stated that the said form filled by the presiding officer is then taken to the constituency tallying center. Abdul Swaleh Jameda, the returning officer for Bura constituency, testified as witness number 8 for the second and third respondents. He stated that they used the biometric mode of identification and the alphanumeric identification. He deposed that he is not aware of any polling station within manual register to identify voters. That was also the testimony of Mohammed Abdi Abdullah, witness number 9, for the second and third respondents, who was the presiding officer at Godia Primary School polling station. Mr. Abdullah, he drained at around 4 p.m. and he called the ICT staff to supply him with another battery, and he got 2 replacement batteries in about 10 minutes. It was his evidence that the last person voted at 11 p.m. since by 5 p.m. Since 5 p.m. when it was his evidence that about 70% of the voters who needed assistance to vote, and that is why since assisted voters take longer to vote than those who do not need assistance. He stated that Godia has no electricity, but he had been given a gas cylinder. The elections were free and fair. It was submitted by Mr. Miller that failure to allow 126 voters at Titila Primary School and Waimboru Primary School polling station had a direct effect on the outcome of the impugned election. When considered alongside all the other grounds, he contended that the second respondents' witnesses all confirmed that they did not use the manual voters register to identify voters in all polling stations within Tana River County. Therefore, this amounted to disobedience of the judgment of the court in Kenya Human Rights Commission and 6 others but APC and 2 others, delivered in 2022. Delivered in 2022, just before the elections, which directed the second respondent to use the manual register, which second respondent to use the manual register to identify voters in the event the KIMS kit failed to identify a voter. He asserted that the failure to use the manual register to identify voters is non-compliance with the law and is sufficient to nullify the election. He stated that at Godia School polling station stream 2, the KIMS kit went to wait under trees in the polling station to shelter from the sun as they waited to vote. However, at 5 p.m., the NYS went to the back of the queue and said that any person behind him in the queue would not vote. Consequently, at least 100 people who turned up to vote were not allowed to vote. He further stated that when one looks at from that 7A from the same polling station, the petitioner got 224 votes, whereas the first one vote. Therefore, if the 100 voters were allowed to vote, the petitioners vote drastically, and this would have affected the final results of the election in petitioner's favor. Professor Ojena relied on the case of Mark Nkonana Supeo and another versus the IEBC and two others, where the court held that it is clear that under biometric identification method, there are elimination stages involved before a printed register is called upon and submitted. He submitted that courts have recognized the various methods of identification using the KIMS kit. The courts have identified the various methods of identification using the KIMS kit. He cited the Supreme Court decision in Raila 2013 and the Supreme Court's decision in Raila 2022 and submitted that there is concurrence in the precedents emanating from the judiciary that technology may be prone to failure and no election should be overturned on a mere glitch. It was something that the petitioner failed to lay a basis for this allegation. In view of the fact that none of the petitioner's agents at Titila and Wayuboru polling stations signed the Form 37A therein, there is nothing to show that they were actually present at the polling station on the day of the elections. On the issue of malfunctioning, KIMS codes at Gordon Primary School polling station, Mr. Munyeria submitted that the person who testified as a petitioner's agent at the same polling station is different from the one who signed Form 37A for the particular polling station. Hence, there is no evidence that the petitioner's witness was at Gordon polling station on 9 August 2022. This is the determination. The petitioner contended that the polling kit failed to identify and some voters were unable to vote. It is not disputed that technology may fail. Therefore, a KIMS kit is prone to failure. Section 44 of the Election Act, read together with regulations 26 and 69 of the Elections Technology Regulations 2017, provide for complementary mechanisms for identification of voters the event the KIMS kit fails to work. The third respondent explained the process of voter identification that was adopted during the 2022 general elections. He said that identification of voters was the first to be done using a KIMS kit. If it failed, the second respondent's officials adopt the alphanumeric search, where the presiding officer uses a KIMS kit and a QR code to search for the names and identity card number of the voters. And if this also failed, they adopt the supervisory mode of identification. It was the third respondent's testimony that at Titila and Wayuboru polling stations, the second respondent's officials used all three modes of voter identification. Hence, to the best of his knowledge, no voter was sent away at the same polling stations. The petitioner's case was that at Wayuboru polling station, 70 registered voters did not vote since they were not identified by the KIMS kit, whereas at Titila polling station, 56 registered voters were turned away for failure to be identified by the KIMS kit. PW8 Hassan Kuru Iluka testified that he was a registered voter at Titila polling station. However, he had two other voters who were standing behind him in line who were not identified by the KIMS it on 2 occasions. In addition, the supervisory mode where the second respondent's agent would have taken photos while holding his identity card and his chin, and therefore thereafter fill his name in a book and allow him to vote, was not used to identify. From the evidence on record, it is clear there was not 70 registered voters at Waimboru. Registered voters at Titila polling station were denied a chance to vote since they could not be by the Kim's kit. In as much as the constituency of Galole the supervisory education board was not used to identify voters in its constituency. The presiding officer for Titila polling station, who was actually averred that it was used alongside the Kim's kit. PW8, who asserted that he was a registered voter at the Titila polling station, had nothing to show that he was indeed a registered voter at the said polling station. In the case of Pius, Yatani Wario, and another versus IBC and 2 others, Chitebwe J, when dealing with a similar issue, held as follows. It is clear from the provisions of Section 5, subsection 5, that upon one being registered, the registration officer is supposed to transmit the information relating to the registration of the voter to the Commission for purposes of inclusion of the voter. It is therefore possible that one can be registered but still find his name not to be in the voters register. That is why Section 6 calls upon members of the public to inspect the voters register for purposes of rectifying the particulars in the register. Section 10 of the Elections Act provides that anyone whose name and biometric data are entered in a register of voters in a particular polling station and who produces the same identification document used during registration shall be entitled to vote. The above provisions clearly stipulate that even after one is registered, that is not the end of the process. There is the need to be included in the voters register. Registration as a voter is not automatic inclusion in the register. It is logical that the voter expects the IBC officials to complete the process. However, a curious voter should be courageous enough to verify his registration status as provided under Section 6 of the Elections Act. The evidence shows that those who allege to have been registered could not be traced in the voters register. Even if we can assume that they had applied for registration, their biometric data was not sent to the Commission for Inclusion. This can be blamed on the IBC staff. However, the candidate in the election cannot be blamed for that anomaly. It was the petitioner's case that a total of 126 voters were turned away and denied their right to vote because they could not be identified by the Kim's kit. It is possible that the alleged voters could not be identified by the Kim's kit because they were not registered voters in the state polling stations. This court further noted that the presiding officers could simply allow people holding acknowledgement slips. Sorry, this is a citation from the case of James Nyoike versus Francis Obingo and others, where the court held that furthermore, possession of a voter's card is not per se evidence that such a voter's name is in the register. Under Section 6 of the Elections Act, voters are allowed to inspect the register within a period and have their names confirmed to be in the register. There is no evidence that the 4 witnesses who swore affidavits in support of the petition's case ever verified their registration status. In light of the state authority and the evidence abused, the fact that the petitioner bears the burden of proof throughout these proceedings, throughout this petition, and the fact that the petitioner's agents at Titila and Waimboru polling station did not sign forms 37A for the state polling stations, there was no way of ascertaining that they were at the same polling station on the election day during the voting. And it is therefore my conclusion that all the registered voters at Titila and Wayuboru polling station who made their way to the polling station and were registered had the opportunity to be identified by the provided modes of identification and allowed to exercise their political rights to vote. Further, the polling station agents usually take notes during the day of elections, but in this case, the notes taken by the state agents were not provided to the court. The petitioner asserted that for polling station stream 2, the KIMS kit malfunctioned and it was taking about 30 minutes to identify a voter before a voter proceeded to vote. Thus causing voting to extend into the night without lighting, hence many voters at the same polling station returned home without voting. The second and third respondents denied this allegation, and Muhammad Abdi Abdullahi, witness number 9, who was the presiding officer for Godia Primary School polling station, testified that the KIMS kit battery drained at around 4 p.m. and thereafter he called the ICT staff to supply him with another battery, and he got 2 replacement batteries in about 10 minutes. It was his evidence that the last person voted at 11 p.m. since by 5 p.m. when the polling station was supposed to close, there were still people queuing. And he attributed the delay in voting to the fact that about 70% of the voters were voters who needed assistance to vote. And I am satisfied that by the explanation offered by the presiding officer as to why the voting process was slow compared to the other polling stations. PW2, the petitioner's agent at Godia Primary School, polling station 2, was sent away when the National Youth Service person went to the back of the queue and stood behind the last person and said that the people standing behind him would not vote. The third respondent contended that a security officer is supposed to stand behind the last person in the queue as is the standard practice. Additionally, at Godia Primary School polling station 2, everyone who was at the queue was allowed to vote. Inasmuch as the petitioner's witness alleged that voting at Godia polling station stream 2 could not proceed between 7 p.m. to 9 p.m., thus people who were still on the queue left without voting since it was dark and there were no lights in the room where the votes were being cast. The witness contradicted himself during cross-examination by stating that he left the polling station at 7 p.m. Thus, if this was the case, one is left to wonder how he knew that lighting was provided at 9 p.m. and what transpired between 7 and 9 p.m. The presiding officer, on the other hand, asserted that the polling station had no electricity, but he had been given a gas cylinder light at about 5:30 p.m., but not work thereafter. He was given a solar light at around 6 p.m. to assist with the lighting situation at the polling station. From the above, can be easily deduced that the kit at the same polling station, that's Godia polling station stream number 2, did not malfunction, and everyone who was at the queue at 5 p.m. was allowed to vote, since voting went on until 11 p.m. Accordingly, this allegation was not proved by the petitioner to the required standards. Interference with ballot boxes and election materials by the second respondent's employees at Bura constituency. PW1, when being cross-examined by Professor Ojeda, in his affidavit at page 37, and on being replied his affidavit on page 37, he stated that the second respondent's employees were arrested while trying to sneak a ballot box that was on a motorbike into the second respondent's warehouse at Bura constituency on 16 August 2022. He further stated that the IEBC stores ballot boxes in a designated place. On being asked when the election results were declared, PW1 responded that the results were declared on 12 August 2022. On being cross-examined by Mr. Munyidia, PW1 stated that the incident was recorded on 16th of August 2022 in OB number 17/16/08/2022. On being cross-examined by Mr. Uganda about the averment in paragraph 19 of his affidavit, PW1 responded that he was informed by the Bura constituency returning officer that on 16 August 2022, 2 temporary election officials had been arrested while trying to take a ballot box from Bura constituency office where it had been kept with other non-strategic material. He further stated that this incident happened 6 days after elections, which were held on 9th August 2022. He referred the court to page 400 of the second and third respondent's document and stated that the results were declared on 12th August 2022, and as such, the incident hearing could not have affected the election results in any way. In regard to the issue of the ballot box that was allegedly being sneaked into the second respondent's warehouse at Bura constituency, the second and third respondents, witness number 8, who was a returning officer for Bura constituency, stated that the transfer of ballot boxes on 16 August 2022 was inconsequential, as it was after the election. He stated that they kept the ballot boxes at the IEBC county warehouses to secure them. He expressed elections at Bura constituency were free, fair, credible, and transparent. Mr. Miller cited Article 86, paragraph C of the Constitution of Kenya 20, and submitted that ballot boxes are strategic materials and they are required to be kept in very safe and secure custody. As the ballot boxes and the contents therein are very critical in assisting the court to determine any subsequent election dispute. He further submitted that once the petitioner presented evidence that a ballot box was found in the wrong place at the wrong time, the evidential burden of proof shifted to the second and third respondents to provide evidence that the circumstances in question were not part of electoral malpractice or breach of the law relating to the elections. In doing so, they ought to have called the clerical staff who were found with the ballot box to testify in court and explain the circumstances under which they were found with it, and or the arresting officer to clear the second respondent of any wrongdoing. Professor Ojenda, on the other hand, submitted that the alleged incident having occurred on 16 August 2022 is of no consequence. In any event, this alleged illegal movement remains nothing but an allegation that is yet to be proved in law. He stated that the petitioner failed to show how the act that happened on 16 August 2022 affected the results that were declared on 12 August 2022. The said submissions were reiterated and supported by Mr. Munyidia, the learned counsel for the second and third respondents. The determination of that issue is that in this instance, the petitioner has failed to explain how the alleged incident of a ballot box being taken to Bura warehouse on 16th of August 2022 affected the election, which was conducted on 9th of August 2022. Declaration of results were made on 12th August 2022 at the county tallying center. At the time the election petition was being heard, the incident was still under investigation. The outcome of the said investigation was therefore unknown. In the case of Samuel Kazungu Kambi vs. Nelly Ilongo, the county returning officer, Kilifi County, and 2 others, The court declined to accept an argument that irregularities occurring after declaration of results at the polling station could have an impact on the outcome of the election. I do agree with the counsel for the first respondent and the counsel for the second and third respondents that the issue of a ballot box being sneaked into the warehouse is inconsequential to this election petition, as it is an incident that is said to have taken place 4 days after the declaration of the gubernatorial results for Tana River County. Mistallying of results from forms, this is another issue. Mistallying of results from forms 37As to forms 37Bs to the advantage of the first respondent, consequently substantially affecting the results. The petitioner's averment is that there is mistallying and interchanging of results between forms 37A and 37B for the election of Governor Tana River County, which information is received from his chief agent, and that the said action substantially compromised the requirement for free and fair elections. He stated that Form 37A for Kitere Primary School Station contained at page 56 of the petition shows that he got 12 votes, whereas the first respondent got 173 votes. However, Form 37B, which is at page 50 of the petition, shows that he got 50 votes, and the first respondent got 50 votes. In Kipao Secondary School, the petitioner stated that the results for Anania Karayu Ndeye, who also contested for the post of the governor for Tana River County, are different. In Forms 37A and B, it shows that he garnered 40 votes. However, in Form 37C, found on page 399 of the second and third respondents' documents, it shows he garnered 406 votes. PW1 stated that according to Form 37A for Konkona Nursery School Polling Station, he got 110 votes and Ali Wario got 90 votes, while Form 37B shows that he got 5 votes and Ali Wario got 0 votes, in addition to the number of total votes in Form 37A, which is 247, while in Form 37B, the votes reflected there are 216. And therefore, he stated that the election process was not accurate and verifiable. And that when it comes to, he's also said that when it comes to Maroi Primary School Police Station, Form 37A shows that the first respondent got 320 votes. However, there was an alteration made against the name of Dida Adam Barisa to show that he had garnered 2 votes instead of 320 votes. According to him, the said alteration was deliberate, since there was no way that Dida Adam Barisa got only 2 votes in his village. In addition, there was no countersigning. In addition, there was no countersigning against the said alteration. The petitioner asserted that upon the perusal of Form 37A, it appears that though the figure 3 was added to the figure 20, it appears as if the figure 3 was added to the figure 20 to give the first respondent 320 votes. In his evidence, he stated that Form 37A for Makere Primary School Polling Station contained at page 165 of the second and third respondents' documents shows that the first respondents' votes have been interchanged with those of Dida Adam Barisa, more specifically, that the first respondents' votes have been changed from 2 to 270. The number of rejected votes was altered to read 7. He, however, stated that inasmuch as the said alterations were countersigned, the same was not proper, as the signature of the presiding officer given on Form 37A of the particular polling station does not correspond on the one shown in the countersigned area of the form. He referred to Form 37A on page 270 of the petition for Maro Wells Polling Station and stated that the total valid votes cast is 115, whereas in Form 37B found on page 166 of the petition, it is 259. He stated that it was recorded in Form 37A for Maroro Madrasa polling station that Nu did not get any votes from the polling station. PW1's complaint. Which one the right? PW1's complaint at Bangale Primary School polling station is that the total votes cast in Form 37A is 353 votes, whereas in Form 37B it is 375 votes. That when it comes to Gomesa Village polling station, Form 37A indicates that Ali Wario garnered 62 votes, and Form 37B indicates he got zero votes. Form 37A for Hone Primary School polling station at page 63 of the petition, on the other hand, indicates that Ali Wario got 64 votes, while Form 37B for the same polling station at page 49 of the petition shows that he got 0 votes. And in addition, the total votes cast in Form 37A is 354, while in Form 37B it is 290. In cross-examination, PW1 stated that Ali Wario did not file an election petition, and even if the 64 votes were correctly captured on Form 37B, he would still not have won the election. The petitioner further referred to Form 37A for Shoragafo polling station at page 395 of the petition and stated that it shows that he got 41 votes, whereas Form 37B shows that he got 0 votes. The petitioner asserted that human errors can occur during tallying of Forms 37A and 37B, but not to the extent of the elections in this petition. The above evidence was corroborated by the witnesses who testified on behalf of the petitioner, and it was not disputed by either of the respondents and or their witnesses who testified on their behalf. Francis Odhiambo, who testified as witness number 2 on behalf of the first respondent and who was the first respondent's agent at Concona Nursery School polling station, stated that Form 37A shows that the petitioner garnered 150 votes, whereas Form 37B shows that he got 205 votes. Therefore, he was added 55 votes. Other witnesses, numbers 6 and 7, Abubakar, Babo Omari, and Said Bakari Kiribai, stated that they were at the polling station when the ballot papers were being cast by voters, and when they were being announced, Dida Adam Barisa got 2 votes, as indicated in Form 37A, and the first respondent got 320 votes, as reflected thereon. The first respondent, who testified as witness number 8, on the other hand, stated that Form 37A for Kitere Primary School shows that Dida Adam Barisa got 2 votes, and the number 320 has been cancelled and written 002, and 002 written. However, it was not signed against. The alteration was not signed. He asserted that it would be wrong to make an alteration if IEBC cannot justify the said alteration. In addition, if it is found that IEBC gave 320 votes in error, it would be fatal to the elections. It was his evidence that the results of the elections are keyed into computers by human beings, and human error is expected to occur. Khadija Mohammed Ahmed, the constituency returning officer for Garsen constituency, testified as witness number 2 for the second and third respondents. She averred that the errors made in transfer and polling recording of results from Form 37A to 37B, Form 37B, was attributed to human error. Mr. Miller, however, submitted that this explanation was not plausible, as human error cannot give the 2 main candidates the exact number of votes, that is 50, and then give all the other candidates 0 votes. He urged the court to disregard the explanation. Abdul Swale Jameda, the Bura constituency returning officer, testified as witness number 8 for the second and third respondents. He stated that there were variations in Forms 37A and 37B of the votes gathered by the candidates for governor's post, and this can be attributed to human error. He stated that for Bangale Primary School, polling station form 37A contained at page 400 of the petition shows that the number of valid votes cast was 353, whereas Form 37B at page 168 of the petition indicates that the valid votes cast was still 353. It was submitted by Mr. Miller that the many errors in recording of results means that the results were not accurate, transparent, and verifiable, thus did not meet the constitutional threshold set in Articles 81 and 86 of the Constitution of Kenya, thereby rendering the entire process null and void. He further submitted that these errors definitely affected the outcome of the elections in view of the fact that the margin of error between the petitioner and the first respondent was 259 votes, making it impossible to ascertain who won the elections for governor in Tana River County. Professor Ojienda's senior counsel submitted that it is instructive to note that the petitioner never called any witness who contradicted the results as captured in Form 37A for Maroni Primary School and Makare Primary School polling stations, or as testified by both Abubakar Babo Omar and Said Bakari Hiribaye. Additionally, he said that Adam Dida never lodged any complaints to the effect that his votes were interchanged with those of the first respondent. Therefore, the allegations therein are unproved and ought to be dismissed with cause. The counsel for the first respondent further submitted that on the allegation that Form 37A for Baramatu polling station 2 had been signed by the presiding officer on behalf of all the candidates or their agents, the petitioner did not call any witness to testify and or corroborate this serious allegation. Thus, it remains nothing but an unproved allegation. He urged the court to consider the Supreme Court's holding in Gatirau Peter Munya versus Dixon Mwenda Kidinji and 2 others, where it was held that procedural or administrative irregularities and other errors occasioned by human imperfection are not enough by and of themselves to vitiate an election. Mr. Munyidi stated that for Kipao Secondary School polling station 2, polling station stream 2, the petitioner alleged that a candidate by the name Anania Karau De garnered 4 votes in Form 37B, but was recorded as having garnered 40 votes in Form 37A. However, looking at Form 37B contained on page 49 of the petition, it is evident that Anania is recorded to have garnered 40 votes. For the errors noted in tallying of the results, Mr. Munyidi stated that it was explained by the 3 respondents as not being deliberate, since the election started on 8th and went on until 12th of August. Therefore, there was a lot of fatigue and lack of sleep for the election officials. In addition, he asserted that data entry may not be perfect, but it did not affect the overall will of the people. He stated that it was not possible. It is not possible to have a perfect election, since elections are conducted by human beings and errors are bound to be made. Therefore, the recording of the number of total votes between Form 37A and B cannot be used to nullify an election. He relied on the Court of Appeal decision in IBC vs. Minor Kiai and 5 others, in the case of Jackton Nyanungo, Ranguma, and IBC versus IBC and 2 others, and further stated that the results at the polling station are final. Thus, by the petitioner does not challenge the results in Form 37A, the same should be dismissed. It was the second and third respondent's case that the petitioner benefits from the errors alleged herein by gaining 52 votes, while the first respondent lost 123 votes. Therefore, therefore, counsel stated that if this error is to be corrected, the gap between the first respondent and the petitioner widens to 434 votes. It was submitted by Mr. Munyida that where a petitioner points out multiple errors in an election petition, it is not enough for the petitioner to only state that there were that were it not for these errors, the results would have been different. He relied on the Court of Appeal holding in Bowen David Kanongo versus Sami Kemboi Kipkewi, where it was held that a petitioner should demonstrate how the winning gap is diminished. The petitioner alleged that Form 37A for Maramtu polling station has been signed by the presiding officer on behalf of all the candidates or their agents. There was, however, no proof that a complaint has been lodged with the police in relation to this allegation. Neither was a document examiner's report produced to ascertain that these allegations are true. Accordingly, it is my finding that the petitioner did not, in the very least, attempt to prove that the claim that the presiding officer signed on behalf of the agents was true. The court in this judgment has tabulated the results for Kipao Secondary School polling stations stream number 2 in a table format as shown on Forms 37A and Form 37B, and for all the 13 candidates who vied and what they garnered. And it's not only for Kipao Secondary School polling station number 2, but also for Konkona Nursery School polling station, Maroni Primary School polling station, Makere Primary School polling station, Maro Wells polling station. And since here we are dealing with 2 candidates, the petitioner and the first respondent. And since this judgment will be available to all the parties and the advocates, I'm going to refer to the petitioner and the first respondent's votes. In Kipao Secondary School polling station 2, in Form 37A, Hussein Tunea Dado got 152 votes, and in Form 37B, he got 152 votes. In the said polling station, Dado Gadai Godana got 1 vote, and in Form 37B, it's reflected as 1 vote. In Form the Konkona Nursery School polling station, Form 37A, Hunea as Hussein Dado got 150 votes, and Form 37B, he got 205 votes. It's reflected as 205 votes. And Dado Gadai Gonana got 1 vote, and Form 37B, it's shown as 2 votes. In Maroni Primary School polling station number 1, Form 37A shows that Tunea Hussein Dado got 8 votes. Form 37A 7B shows he got 8 votes. Dado Gadai Godana is shown to have got 320 votes, and in Form 37B is shown to have got 320 votes. For Makere Primary School polling station 2, Tunea Hussein Dado is shown to have gotten 7 votes. That is on Form 37A. Form 37B, 7 votes. Dado Gadai Godana is shown to have got 270 votes, and on Form 37B, 270 votes. For Maro Wells polling station, Form 37A, the results for Tunea Hussein Dado are given as 51 votes, and also on Form 37B as 51 votes. Form 37A, the results for Dado Gadai Godana are given as 0 votes, and on Form 37B as 0 votes. For Maroro Madrasa polling station, Form 37A, Tuneya Hussein Dado is shown to have got 66 votes. From 37B, he shown to have got 66 votes. Dado Gadai Godana got 120, is shown to have got 120 votes on Form 37A and 120 votes on Form 37B. Bangale Primary School polling station, Form 37A, Tuneya Hussein Dado is shown to have got 36 votes on Form 37A, and on Form 37B to have got 36 votes. And Dado Gadai Godana to have got 1 vote on Form 37A, and Form 37B to have got 1 vote. And Gomesa Village polling station, Form 37A, Tuneya Hussein Dado is shown to have got 92 votes. From 37B, he's shown to have got 92 votes. Dado Gadai Godana from 37A is shown to have got 1 vote. From 37B, 1 vote. Kone Primary School polling station 1, from 37A, Tuneya Hussein Dado is shown to have got 286 votes. From 37B, he is shown to have got 286 votes. And from 37A, Dado Gadai Godana is shown to have got 1 vote, and from 37B, 1 vote. And Shoragapo polling station, from 37A, Tuneya Hussein Dado is shown to have got 41 votes, and from 37B, 41 votes. And Dado Gadai Godana have got 0 votes, and from 37B dash. So those were the contested, the polling stations where it was contested that there were variances between the votes reflected on Forms 37A and 37B. An analysis of the above tables shows that the variances of votes between Forms 37A and 37B were minimal, and in any event, bearing in mind that the Supreme Court has said time and again that the A-series forms are the primary documents to be used in collation votes. From the available documentation, the appears in mismatch of votes or transposition of votes from 37A to 37B cannot be said to have appeared in benefit, as it not only affected the petitioner and the first respondent, but according to the tables here, it affected all the other candidates. And therefore that grounds fails, and those variances cannot vitiate the election. The other issue is whether the elections of the governor Tana River County held on 9th August 2022 was accurate, transparent, and verifiable, and whether the said elections met the minimum threshold. Whether it met the minimum threshold of a democratic electoral system and process as set out in Articles 81E, 81, paragraph E, paragraph B, 2, 4, and 5. Sabbatical 2, 4, and 5. Article 84 of the election of the Constitution of Kenya 2010, and with all other election laws. This issue answers both The above answers both issues numbers 14 and 15 in the list of issues adopted by the court and the parties hearing. The petitioner's case is that the elections hearing did not meet the minimum threshold. The threshold of a democratic electoral system and the process is set out in Articles 81E, subparagraph E, and Article 81, subarticles 2, 4, and 5, Article 83, 2, Article 84, Article 86, and 88.4 of the Constitution of Kenya 2010, read together with the election laws, Elections Act 2011, Election Laws Amendments 2017, and Elections General Regulations 2017, and the Electoral Code of Conduct 2017. The petitioner's case is that the elections for the governor did not meet the threshold. It was evidence of PW1 that in the just concluded elections, in the elections that were concluded and that given rise to this petition, there were incidents of mistallying results from Form 37A to 37B, and thereafter to Form 37C. Opening of ballot boxes for Kitere Primary School polling station and Kipao Secondary School polling stations, stream number 1 at Garsen Constituency Tallying Center without a court order, and counting of votes at the tallying center, shortage of ballot papers for governor elections at Nyangwani polling station and Cowell's polling station, thus disenfranchising voters of their right to vote, and having a negative impact on the petitioner, since these were some of his strongholds. There were also allegations of failure of Kim's kit at Titila Primary School Station and Waiboru Primary Polling Station, resulting to voters being turned away, and they were thus unable to vote, since no other mode of identification of voters was adopted by the presiding officers at the said polling stations. There was also the allegation of the complaint of malfunctioning of Kim's kit at Godia Primary School polling station, stream 2, causing voters voting to extend into the night without lighting, hence many voters returning home without voting. The petitioner stated that the third respondent, who was a county returning officer for Tana River County, signed Form 37B for Garsen constituency, a function and duty reserved for the constituency returning officer, and the deputy constituency returning officer in the absence of the county returning officer, that the counting and tallying of results led to an erroneous result, since some of the second respondents' agents were arrested on 16 August 2022 by trying to sneak a ballot box into the second respondent's warehouse at Bura constituency. And it was his evidence, the petitioner's evidence, that Form 37B for Bura constituency did not contain votes for 3 of the 13 candidates vying for the seat for governor for Tana River County. And he asserted that the presiding officer for Marmut polling station stream 2 signed Form 37A on behalf of all the political parties' agents, and in some of the polling stations, not all agents signed Form 37A due to the fact that they disagreed on the results contained therein, and or with no explanation whatsoever. The petitioner therefore stated that the election process was flawed so as to favor the first respondent. PW2 Abdullahi Gudo testified that he was the petitioner's chief agent, and he corroborated the testimony of the petitioner. He stated that all his agents were at the polling stations spread across Tana River County from the time voting started to the time the results were announced. However, he was not at the polling stations, and he was relying mostly on information received from the said agents. It was his evidence that the results of Kipao Secondary School polling station stream 1 were not announced at the polling station Thus, the petitioner's agent did not sign Form 37A for the polling station, despite the fact that he was at the polling station the entire day. His evidence was that Form 37A was that Form 37A for Kitere Primary School polling station was not signed by the presiding officer or his deputy, and the space provided for polling station counts was not filled, and it does not bear the IBC's term. He confirmed that Form 37A contains the final results of each polling station, but he could not confirm whether the alleged signature for the petitioner's agents, Said Mugawa, that can be seen on Form 37A for Kitere Primary School polling station was actually his. PW4 Mohammed Shabaro was the petitioner's agent at Kipao Secondary School, Stream 1. He stated that signing of Form 37A was voluntary and not by force. He further stated that he did not sign Form 37A since it was not filled at the polling station, despite the results having been announced at the polling station. Looking at the evidence of PW5 Maro Awadi, UDA's agent at Nyangwani polling station, this court notes that he disagreed with most, if not all, the amendments contained in his affidavit filed in court. However, he testified that no one was chased from the polling station, but at around 2 p.m. there was a shortage of ballot papers for the election for governor, and therefore almost half of the registered voters were not able to vote for their governor of choice. He contended that the said polling station was one of the petitioner's strongholds. PW6 Peter Karanja, the presiding officer for Kabawest polling station, stated that only 69 people voted for all the electoral posts. He further stated that there was a shortage of ballot papers for the governor elections, but the other elective posts had sufficient ballot papers. However, the voters therein became agitated, hostile, and declined to vote for the other elective posts due to the said shortage. He stated that his comment on Form 37A should have been that the election was not credible since the elections for the governor stopped. When asked why he did not testify on behalf of the second respondent, since he was one of its officers, he stated that he was not approached by the second respondent to do so. PW7, an agent at Titila Primary School polling station, on the other hand, asserted that 56 registered voters did not vote because they could not be identified by the KIMS kit, which was the only mode of identification adopted by the presiding officer therein. Therefore, he declined to sign Form 37A. Hassan Kuru Luka testified as PW8. His evidence was that he was aboard at Titila Primary School polling station, and he together with 55 others were unable to cast their votes since they were not identified by the KIMS kit. On 2 attempts, and no other form of identification was used to try and identify them. Yakub Dubedido, an agent at Wayuboru Primary School polling station, was PW9. He stated that 70 people were not allowed to vote since the KIMS kit failed to identify them. And they were not allowed to vote manually. PW10 Dawoodi Siad, an agent at Godia Primary School polling station, deposed that the KIMS kit malfunctioned and took too long to identify voters. He stated that over 100 people did not vote since they were blocked by an official from the NYS. In addition, there were no lights at the polling station, and a light was only brought at 9 p.m. He stated that he did not sign Form 37A since he did not agree with its contents. I note that by the time the petitioner closed his case, he had not called his agent for Kitere Primary School polling station, which I had already stated before, Said Mugawa, to testify on the events that took place at the polling station on the day of elections, despite the fact that his name came up several times. The petitioner had so many complaints and all allegations with regard to these polling stations, and therefore I'm of the considered view that Mr. Said Mugawa was better placed to assist the court in understanding what really transpired. What really transpired at that particular polling station for the court to make a determination on the petitioner's allegations. And as the court earlier held, it goes by what was stated by the chief, the county returning officer, the constituency returning officer, and the two agents who were at the polling station, and the presiding officer for the said polling station. Gawawa Said, the first respondent's witness, number one, testified that he was a ward coordinator and an agent for Kinyandu Primary School polling station. However, he was at the Garsen constituency tallying center, and the governor's ballot box for Kitere Primary School station was opened and votes counted in front of all the agents present. And thereafter, all the agents signed Form 37A. And that his allegation gained support from Salad Ijema Mkenge, a ward coordinator who testified as witness number 4. However, this court has found that this witness by the name Gawawa Said was not a credible witness, and the court, as he kept on contradicting himself, and therefore the court, having discredited his evidence cannot give any weight. Witness number 2. There is a witness number 2, Francis Adiabo, the first respondent's agent at Konkona Nursery School, Nursery Polling Station, and witness number 5. And witness number 5, Mwatamu Haji Labai, the first respondent's agent at Kitere Primary School polling station, who confirmed that they did not sign Form 37A. Mwatamu further said that the votes were counted at the polling station. Another witness, Abubakar Babo of Mari, testified as witness number 6 for the first respondent. He asserted that he was an agent at Maroni Primary polling station alongside Bakari Rimbaya, who signed Form 37A. He said that the results on Form 37A are accurate and they were not altered in any way. The first respondent testified as witness number 8 and stated that he did not cause any breaches of the law. His evidence was that the instances where the KIMS kit failed to identify voters, alternative modes of voter identification were used. It was his evidence that Nyangwani polling station was his stronghold and the shortage of ballot papers therein was occasioned by the printing firm. In addition, he stated that inasmuch as the presiding officer for Nyangwani commented on Form 37A that it was unanimously agreed that the voting shall continue despite the shortage of governor's ballot papers, it cannot be agreed unanimously to deny voters of the right to vote. He deposed that transfer of votes from 37A to 37B from 37A to Form 37B should not change. However, it is possible for numbers to change in the process of the transfer of the votes, and the IBC should justify changes, if any. It is the degree of unjustifiable issues that will determine the credibility of the elections. Witness number 9, Bakari Wayu Abiyu, the first respondent's agent at Kone Primary School polling station, testified that Form 37A was signed by himself, the presiding officer, and the deputy presiding officer. He stated that some votes could not be identified by the Kim's kit, however their photographs were taken and they were allowed to vote. The third respondent testified that election is a process and it is not just about numbers, and that the constituency returning officer for Garsen constituency opened the governor's ballot box for Kitere Primary School polling station at the tallying center in his presence to retrieve the polling station diary. He further stated that the Kenya Gazette 9978 of 12 October 2017 under the first schedule gives authority for opening of ballot boxes at constituency tallying centers. At constituency tallying centers to retrieve materials wrongly put in the ballot box. He deposed that it is illegal. He stated that it is illegal to count or recount votes at the tallying center, and stated that the governor votes for Kitere Primary School and Kipao Secondary School Stream 1 station were not counted at the tallying center. He stated that he signed Form 37B for Garsen constituency after the constituency returning officer had prepared it because she had to leave in a hurry and escort the presidential results to the National Tallying Center at Nairobi. He confirmed that there was a shortage of ballot papers for the governor elections at Mwangi and Kabawel's polling station. He stated that it was not a deliberate effort to suppress voters. In his testimony, he said that an agent only signs Form 37A once the results have been announced and agrees with the results. And he contended, his contention was that the UDA agent did not sign Form 37A for Kipao Secondary School, polling station 1. Because he was not at the polling station. He denied announcing any results at the tallying centers on grounds that he is not authorized to do so. It was his evidence that no voter was turned away due to failure of Kim's kit machines, since there was no record in Form 37As of such incidents. In regards to Titila Primary School polling station, his evidence was that all modes of voter education were adopted, that in as much as the Kim's kit at Godia Primary School polling station Stream 2 failed, the ICT officer was sent by the constituency returning officer to start it and rectify the situation. Khadija Mohammed Ahmed, the constituency returning officer, who testified as witness number 2 for the second and third respondents, stated that in as much as the election rules and regulations ensure free, fair, and accurate and credible elections, they allow for mistakes to be made. She stated that she had 2 deputy constituency returning officers and they had authority to carry out all the functions carried out by the constituency returning officer. She stated that she authorized the presiding officers for Kitere Primary School and Kipao Secondary School polling stations to open the governor's ballot boxes and retrieve the polling station diaries. However, the polling station diary for Kitere Primary School polling station got lost after it was retrieved. This information, she said, is however not contained in her affidavit. And she did not have proof before the court to show that there was compliance with the rules and regulations for opening a ballot box to retrieve a polling station diary, since the polling station diaries for the 2 polling stations were not in court. It was her evidence that the errors of transfer of results from Form 37A to Form 37B is attributed to human error. Nelson Karuku Moya, the presiding officer for Kipao Secondary School polling station number 1, on the other hand, testified as witness number 3. He stated that he counted and announced the results at the polling station, but locked the polling station diary in the ballot box. And he arrived. He stated that on arrival at the constituency tallying center, he opened the ballot box on authorization and retrieved the polling station diary, sealed it, sealed it and recorded the seal numbers of sealed it and recorded the seal numbers of the seals used to lock the ballot box. He denied recounting of votes at the tallying center and averments contained in paragraph 14 of his affidavit that the constituency returning officer is the one who opened the ballot box at the tallying center. It was his testimony that he signed Form 37A at the polling station. Another witness number 4, Fred Wafula Wanjala, presiding officer, Kitere Primary School polling station, said that he forgot to sign Form 37A due to fatigue. He corroborated the evidence of Garsen CRO in regard to the opening of the ballot box for his polling station, and stated that he does not remember recording seal numbers for the seals used. The constituency returning officer for Galole constituency, on the other hand, testified as witness number 5 and stated that the polling stations in his constituency mostly used KIMS kit for voter identification. However, there were 2 other modes of voter identification, the alphanumeric search and the supervisory mode. He deposed from the voting pattern at Nyangwani polling station. The first respondent was most likely to get more votes and had all the voters cast their ballot papers. He further stated that he did not receive any report of electoral malpractice, and the alteration on Form 37A for Makere Primary School polling station was countersigned. He stated that the shortage of ballot papers for governor of Nyangwani polling station was only noted during the voting, since the serial number ranges on top of the carton box ranged up to 226 ballot papers. Hence, this was a printing error and or mistake. The presiding officer for Titila Primary School testified as witness number 7 and stated that they used KIMS kit and the manual search for purposes of voter identification. He denied the petitioner's allegations that 56 voters were not allowed to vote, and said that no voter was turned away from voting. He stated that his station there were more than. He stated that in his state polling, in the polling station he was in charge of, there were more than 80%. There was more than 80% voter turnout. %80 voter turnout, since there were 453 valid votes out of 572 registered voters. Witness number 8 was the constituency returning officer for Bura constituency, Abdul Swaleh. He testified that the polling stations in his constituency used biometric and alphanumeric search for voter identification. He stated that no voters were denied an opportunity to vote, and the transfer of ballot boxes on 16th August 2022 was inconsequential, as this was after elections. The presiding officer for Godia Primary School polling station Stream 2 testified as witness number 9. He stated that the KIMS kit battery drained at 4 p.m., but it was replaced within 10 minutes. He also stated that everyone who was in the queue as at 5 p.m. voted, since the last person voted at 11 p.m. when the polling station was closed. It was his evidence that they were given a gas cylinder light. However, when he tested it at 5:30 p.m., it did not work, so he was given solar lights at 6 p.m. It was his evidence that 70% of the voters needed assistance to vote, and that is why voting took so long. It was the respondents' witnesses were in agreement that the voting process went on smoothly, and that the elections are free. Were free, fair, and credible. In addition, the third respondent stated that election observers and monitors gave electors a clear bill of health, a clean bill of health. He also said that the second respondent put in place a robust institutional and statutory framework to ensure that the elections on 9 August 2022 were free, fair, and credible. The constituency returning officer, Galole constituency, on the other hand, testified that the election was above board, and he was even awarded a certificate for conducting elections. Professor Ojenda submitted that the text laid down by case law is that an election court will not void on mere errors and minor infractions. He relied on the holding by the Supreme Court in Raila 2017 and submitted that irregularities complained of in the instant petition are minor administrative errors that are not fundamental enough to overturn the will of the people of Tana River County. He further relied on the case of Takto Nyanunga Ranguma versus the IEBC and 2 others, and submitted that an election court is not expected to justify easily upset an election unless it is established to the required standard of proof that such non-compliance with the Constitution and the law, the irregularities and electoral malpractices complained of render the said elections invalid. He also asserted that no evidence whatsoever was led to the effect that there was systematic breaches of the law that made it impossible to determine the winner. He referred to the holding of the court in Richard Edile and another was Patrick Musimba, and stated that courts will strive to give effect to the political choices made by the people at the ballot as much as possible to the extent that such choices are clearly ascertainable. In submitting that it is a principle of law that courts will strive to preserve an election as being in accordance with the law, where the results of the election are unaffected by the alleged breaches of the law, Mr. Munyede relied on the case of John Fitch versus Tom Stevenson and 3 others. And the Court of Appeal decision is Zahir, Jada, and another was the IEBC, where the court held that the election is an expression of the will of the people, which must be protected and respected. He also cited the case of John Okello Nagwa and the IEBC and others, and Abdin Nasir Yassin Ahmed and 2 others, and asserted that where the petitioner did not prove how the allegations affected the results, the court should dismiss the petition.
Hello? Yes.
Professor?
Hassan Amandia. Why you? On Monday. Why you on Monday?
On that issue, the determination of the court is that the petitioner contended that the gubernatorial elections in Tana River County held on 9 August 2022 was tainted with serious illegalities, substantial irregularities, and electoral malpractices on the part of the second and third respondents, rendering the announcement and declaration of the first respondent hearing null and void. He averred that the irregularities show that the system can be manipulated, consequently affecting the process. Therefore, he lost the elections because the election process was flawed and manipulated by the IBC. He also stated that the mistallying of results from Form 37A to 37B added more votes to the first respondent. And if that had not been done, the petitioner would have won the election, considering the margin was very small. The first respondent, on the other hand, testified that the instances where votes were not added to the final tally of votes could not change the outcome of the election results. He said that the shortage of governor ballot papers cut across the elective positions, hence it did not give him any undue advantage over the other candidates. He asserted that the issues raised in the petition hearing are in respect to 16 polling stations, making it 3.5% of the total polling stations since Tana River County. Since Tana River County has 368 polling stations, 140 in Garsen constituency, 110 in Galole constituency, and 118 in Bura constituency. The third respondent deposed that the data entry may not have been perfect, but it did not affect the overall will of the people of Tana River County. In addition, errors cited by the petitioner could not have affected the outcome. Of the election results. These sentiments were echoed by Hadija Mohammed Ahmed, the constituency returning officer, Garsen constituency, who testified as witness number 2 for the second and third respondents. The said witness stated that the petitioner had 4,243 votes in her constituency. Thus, even if he was added 86 votes, he could not have won. The constituency returning officer, Bura constituency, on the other hand, asserted that the errors complained of by the petitioner could not have affected the outcome of the results. On this issue, the court has considered the applicable provisions of the law, that is Section 83 of the Elections Act, and the cases that have been relied on by the counsel for the first, second, and third respondents, which are applicable. Nullification of elections is provided for under Section 83 of the Elections Act, which provide as here under subsection 1. A court shall not declare an election void for non-compliance with any written law relating to that election if it appears A, that the election was conducted in accordance with the principles laid down in the Constitution and in that written law, and B, the non-compliance did not substantially affect the result of the election. Subsection 2. Pursuant to Section 72 of the interpretation. Pursuant to Section 72 of the Interpretation and General Provisions Act, Cap 2, a form prescribed by this Act or the regulations made thereunder shall not be void by reason of a deviation from the requirements of that form, as long as the deviation is not calculated to mislead. In the case of Zahir Jada and another versus IBC and 3 others, the court held that the court held that an election is an expression of the will of the people, which must be protected and respected. The court then proceeded to hold that no elections are 100% perfect. There are bound to be mistakes here and there. However, if those mistakes do not affect the result, the court will be slow to nullify such an election. It was perhaps with this in mind that Section 83 of the Elections Act was enacted. The Supreme Court of Kenya captured this legal principle in the case of Gitirao Peter Munya versus Dixon Mwenda Idinji and 2 others, where the court stated as follows. if it should be shown that an election was conducted substantially in accordance with the principles of the Constitution and the Election Act, then such election is not to be invalidated only on ground of irregularities. Where, however, it is shown that the irregularities were of such magnitude that they affected the election result, then such an election stands to be invalidated. Otherwise, procedural or administrative irregularities and other errors occasioned by human imperfections are not enough by and of themselves to vitiate an election. In this regard, we stand on the same plane as the learned judges in Morgan, Opis, and Nana, paragraph 218. Under section 83, not every non-compliance with election laws suffices to nullify the results of the election. The section provides that no election shall be declared to be void by reason of non-compliance with any written law relating to the election if it appears that the election was conducted in accordance with the principles laid down in the written law, or that such non-compliance did not affect the result of the elections. Having analyzed all the issues so far determined, it is my finding that the IEBC there were several missteps made by the IEBC and some irregularities that took place during the elections. But in this court's view, and after analyzing the analysis made, the said missteps and procedural irregularities are not of such a magnitude so as to affect the outcome of the elections. And they have not substantially and materially affected the results of the election or the gubernatorial position. The other issue is whether the first respondent, Gadae Godana, was duly elected as the Tana River County Governor and whether his election should be upheld by this court. The first respondent averred that he won the elections by 26,982 votes as per Form 37C, whereas the petitioner got 26,633 votes. He further averred that he was given Form 37D by the second respondent and he was gazetted as the winner of the elections for Tana River County. It was submitted by Mr. Miller that the first respondent was not validly elected since the electoral process failed to meet the threshold of a democratic electoral system and the process set out in Article 81E, Sub-Article 2, 4, and 5, Article 83, Sub-Article 2, Articles 84, 86, and 88, Sub-Article 4 of the Constitution of Kenya 2010 as read together with the Elections Act 2011, election regulations, and the Electoral Code of Conduct, and the Electoral Code of Conduct are not followed. The elections did not proceed and failed to meet that threshold. In addition, the process was irredeemably compromised, hence the court should nullify the election of the first respondent as the governor of Tana River County. Mr. Munyidia submitted that courts will strive to give effect to the political choices made by the people at the ballot box as much as possible to the extent that such choices are clearly ascertainable, as was explained by the court in Richard Kalembe Dile and another was Patrick Musimba, Moyo, and two others. And also the Court of Appeal decision in Nixon, Cor Nicholas versus IEBC, and two others. And he also submitted that the petitioner in this case has failed to provide cogent and ascertained factual premise to overturn the election, but has only provided conjectures. Mr. Munyidia urged this court to uphold the first respondent's win and to be guided by the holding of the Supreme Court in the Munya case at paragraph 202, where it was held that a recount, retally, or scrutiny does not change the final result as to the gaining of votes by candidates or the margin of victory, however narrow, is material as a factor in the proper election outcome. And he also submitted that the petitioner did not prove any allegations substantial enough to disturb the Tana River, a gubernatorial election conducted on 9th August 2020. This court has already said enough to demonstrate that the election of the first respondent, Dado Gadai Godana, was duly elected. The election of the first respondent, Dado Gadai Gadana, as the Tana River County Governor was done in accordance with the law, and the missteps that were done by the IBC, that is the second respondent, were not substantial as to vitiate his election. I therefore dismiss the petition and make the following orders. 1, a declaration. I hereby make the following orders: a declaration that the election of the governor, Tana River County, held on 9th August 2022 was conducted in accordance with the principles laid out in the Constitution of Kenya 2010 and the applicable electoral laws and regulations, and the results declared on 12th August 2022 and gazetted on 23rd August 2022 are valid. 2, a declaration that Dado Gadai Godana was validly elected as the governor, Tana River County. And 3, a certificate of the election court shall be duly issued by the election court as to the validity of the Tana River County gubernatorial election held on 9th of August 2022. On the issue of costs, submissions were made and the court has considered the said submissions. Mr. Miller asserted that the cost should follow the event. Therefore, the respondent's hearing should bear the cost of the instant application jointly. The respondents urged this court to dismiss the instant petition and condemn the petitioner to meet the cost of the petitioner. Section 84 of the Elections Act provides that an election court shall award the cost of an incidental to a petition, and such cost shall follow the cost. Professor Ojenda urged this court to dismiss the petition hearing with cause for failing to meet the materiality test set out under Section 83. Section 83 of the Elections Act, and he relied on the case of Dixon Mwanda Kidinji and submitted that given the severity of the preposterous allegations that were made, the extreme pressure and the voluminous pleadings involved, the cause hearing should be capped at shillings 10 million. Mr. Munyedhia referred to the case of Dixon Mwenda Kidiji, Gatirao, Peter Munya, and 2 others, and stated that it is an accepted principle that costs follow the event. Thus, the petitioner should bear the cost of the petition. He asserted that Rule 30, Sub-Rule 1 of the Election, Parliamentary and County Elections Petition Rules 2017 empowers those court to determine the total amount of costs payable at the determination of the petition. Therefore, this court should take into consideration the time and intellectual industry employed in the litigation in this matter. The voluminous documents involved during the preparation and conduct of the matter. It is true that costs follow the event. However, in this instance, it is clear that the second respondent, the IBC, did some missteps or engaged in some missteps, which therefore, in a way, has contributed to the filing of the present petition. And therefore, it is the holding of this court that it is not only the petitioner who should bear the costs, but the IBC should also be made to bear the costs. I therefore order that the petitioner shall pay the costs of the 3 million to the first respondent, and the IBC, which is the second respondent, shall pay costs of 2 million. Those are the orders of the court.
Oh. Oi.
The advocates are at liberty now to address the court.
Sit down low.
if they are still there.
Yes, but
Brian,
already we are still here. Still here.
Okay. Yes. What?
Already we are still here. We had to change our budget because of the internet issues.
Who is
Yes,
When I put the petitioner,
Okay.
I'm having a challenge with my camera.
Okay, just a minute. Just a minute, Mr. Wena.
I'm my advocate.
Just a minute.
Who is
I request you to keep quiet. They are still proceeding taking place. Who is present for the petitioner?
I'm still present. When the petitioner,
Simba Tana.
Who's for the first respondent?
My lady, can you hear me?
Yes. Yes.
I'm present. My name is Ogada.
And for the second?
my lady, we are present here with Mr.
Mr.
Mwangi and Mr. Mkaya. We are present. My name is Justice Munyithi.
Oh, that's Mr. Mutugi. I was seeing Mr. Mutugi, so I've written Mr. Mutugi. Okay, Mr. Mutugi is also there.
Mungi is also there, yeah.
Okay.
I'm present here.
Okay. Yes, Mr. Wena, you are addressing the court.
Sorry, my lady, my camera seems to be a bit faulty. We have to change the gadget we're using.
Yes.
So I apologize for that.
Yes.
My lady, we thank you for the judgment.
Yes.
Correct?
Win.
The court is in session. Please, can you keep quiet? Mr. Wena?
Huh?
Mr. Wena? Mr. Wena? I can't hear Mr. Wena. Okay, Mr. Who's for the first respondent?
I am present.
Okay, just a minute. Let me see if Mr. Wena will get back. Mr. Wena? Okay, Mr.
Yes, my lady. On the part of the first respondent, my lady, I want to thank you profusely for I'm on our in this matter.
I can't hear you well, Mr. Ogada. Yes? You have muted yourself.
I'm saying there's a lot of noise, my lady, from the people of Tana River County.
Yes.
On behalf of the first respondent, we say thank you, my lady, for your hard work, for sitting for long hours, my lady, to determine this issue, which is of utmost importance. not only to the country, but to the great people of Tana River County. It is a demonstration that the will of the people is supreme. And in our opinion, my lady, the time for elections has ended, and it is time for the first respondent to work for the people of Tana River County. 5 years is a short time. It is now time to work. Thank you very much to all our colleagues, to Mr. Munyidhia, Senior Munyidhia, to Senior Mr. Mutugi, to my learned colleague, Mr. Mokaya, and last but not least, to my two seniors, Mr. Miller and Mr. Wena. They put up a spirited fight, but by the end of the day, one party must win. And this is not the win for advocates, it's a win for the great people of Tana River County. Thank you very much, my lady.
It's my lady, before I start off, before I lost
Just a minute. I'm still writing. Yes, Mr. Wena?
Sorry, I was disconnected, but I'm now back. But
Yes.
maybe I thank the court for the judgment and the time put in by the court. And also for the courtesy extended to all advocates during the hearing. We'd also like to thank our colleagues for the civil manner in which the proceedings were conducted, which I agree was all with respect for one another. The judgment is long. As we have seen, we've been here for several hours. We to be punished with a corporate judgment.
Just a minute, Mr. Wena. The proceedings are still on. Bado hatujamaliza, kwa hivyo msherekee baadaye, sio sahi. Yes, the judgment is...
Copy of the judgment.
Okay, the judgment is... So I pray for a copy of the judgment in the shortest time possible.
Yes, maybe. We also had the proceedings given to us.
Munyamaze, mugoje koti imalize kazi. Mwache kuongea kama wakili wanaongea. Yes, Mr. Wena? Yes?
We had some proceedings given to us when we were preparing submissions.
Yes.
So my lady would ask for the remaining proceedings.
Okay. Okay.
From the time of from the time of filing submissions to today, certified. We apply for those also within the shortest time possible, my lady.
Okay. Mr. Who else has not spoken?
Yes, my lady, we want to fully associate ourselves with our colleagues in thanking you for the timely case management skills that you employed in this matter. We thank you for the long judgments. Again, a clear demonstration from the judgment that we need to have confidence with IEBC as the electoral management body, even where we have human errors. I also like to thank you for the courtesy you showed us throughout the proceeding, Malindi, and virtual proceeding during the submissions. Indeed, the generation that comes after us will love you in the praise of history for the manner in which you handle this matter for Garsen. I also want to extend my thanks to my colleagues, my two classmates, Wena and Mila, Senior Counsel, Professor Jenda, Mr. Ogada, Mr. Mutugi, and Mr. Mukaya, for the industry in terms of what we made to have the jurisprudence that you have pronounced made today. We are told that lawyers will retouch of the jurisprudence, but judges pronounce it, and you have pronounced it. We shall be applying, you supply us equally with certified copies of the remaining proceedings and judgments for today. And I wish you all the best in your next 12 duty. May God bless you. Thank you.
Okay, thank you very much for your kind words. You'll have a paragraph in my judgment. Also appreciating you for your industry. You put in long hours. You really worked hard with a lot of commitment to your clients, and you are committed. I must say you're very committed. Even your submissions just speak volumes about your degree of commitment. And you also conducted yourself with a lot of effort, for which I appreciated. And I also wish you well as you continue to defend your clients in this petition, if it goes on appeal and in other matters. Thank you and have a good evening.
Have a good evening, Judge.
Thank you very much, Felix. Thank you.
Thank you, Judge.
You get the judgment next week.
Thank you.
Thank you, Judge.
Okay, thank you. Sasa natoka kotini, nimekaa hapa sana.
Your Excellency, the government.
Asante sana.
Thank you, Judge. Thank you, Judge.
Thank you.
We are very happy.
Thank you, Judge.
Miaka mitano ya shida, miaka mitano ya shida inakuja. Miaka mitano ya shida inakuja. Taarifeni miaka mitano ya shida. Miaka mitano ya shida. Miaka mitano ya shida. Miaka mitano ya shida inakuja.
Miaka mitano ya mafanikio ndio inakuja.
Miaka mitano ya shida inakuja. Mujitandae vizuri.
Wewe shida ni wewe.
Miaka mitano ya shida inakuja. Tunalipa.
Miaka 650.
Miaka mitano ya shida tunalipa.
Miaka 650.
Guys.
Mateso, magonjwa,
Guys, ni Abdul Malik bin Marwan. Wacha tuheshimu maoni ya kotini. Guys, ni Abdul Malik bin Marwan. Wacha tuheshimu maoni ya koti. Koti inaamua. His Excellency Dr. Retired Major.
Miaka 650 bwana.
Hassan Moroa.
Let us respect the court decision.
Miaka 650.
Tumeenda kotini, imesemekana ni Dr. Meja. Asanteni sana. Mimi nilikuwa Malik Marwan nikiwaletea live ya hii petition. Nimefurahi sana, over 6,000, almost 10,000 views. Asanteni sana na Mungu awabariki.
Miaka 650.
Thank you guys. Hiyo ndio namalizia. Thank you so much for watching my live feed. Asanteni sana, Mungu awabariki. This has the end of our live feed. Asanteni sana, Mungu awabariki.